Dear colleagues, we're studying the second panel, mediation in justice, business, and labor, and we have a lot of creative speakers who are ready to share with the results of their research in mediation in business and labor. And we will start with our online speaker. I give the floor to my co-mediator, Maxim Yenin. Maxim. I'm here. I hope you can hear me. Hello, dear colleagues. First of all, um, mm, on behalf of the Kiev National Polytechnic University named by Igor Sikorsky, I'm happy to welcome all the participants of our conference. The participation in this event is very important for our university. The topic of mediation and alternative settlement of disputes is the topic that is very relevant to the modern challenges in a lot of areas of life, and it's kind of the topic of intersectional interaction. I'm at the moment acting head of the Department of Sociology of Igor Sikorsky Polytechnic Institute, and I wish all of you the fruitful discussion, and I hope you will get some inspiration and the topic of mediation in Ukraine and beyond, and I encourage you to participate actively in our panel. And now I'm happy to give the floor to Professor Fatan Shabani, who will give his speech.
PhD in law, a professor at the Faculty of Law at Tetovo University in North Macedonia. Professor Shabani, hear us? You hear us?
Hello to everyone.
Yes, hello. Are you ready to start?
Yes.
Yes. Okay. Professor, the floor is yours. Thank you very much. If you have a presentation.
Yes, just to share it.
Professor, we don't see you. If it's possible, it would be great to see you.
I share it already.
Yes, presentation. Yes, is visible.
10 minutes,
okay.
Please. Our deadline, 10 minutes.
We see presentation, but we don't see you personally.
Yes.
If it's possible.
Yes. Yes, thank you for this opportunity to present my research about the practical application of mediation in business, with a special emphasis in the case of Republic of North Macedonia. In introduction, disputes or conflicts occur in all human relations, societies, and cultures. From the beginning of the written history, there is evidence that of dispute between children, spouses, neighbors, collaborators, organizations, communities, populations, and their governments, ethnic, religions, and racial groups, as well as different nations. Alternative dispute resolution, or ADR, is not a new phenomenon for dispute resolution. It was presented before the litigation was development. Small and medium-sized enterprises, or SMEs, can be involved in business-to-business disputes with customers, suppliers, and partners. SMEs, especially small enterprises, are deterred from starting legal action by the duration and cost of these procedures. If the counterpart in the disputes is a large enterprise, it is likely to have more expensive and experienced legal assistance. Furthermore, judicial litigation often ruins relationships. Altogether, judicial litigation is often no real option for SMEs. By voluntary participating in the mediation process, fear and anxiety of parties are greatly reduced. One of the most distinguishing features of the mediation compared to other processes is that it tends to involve the disputing parties directly in the resolution. In international background, the UN commitment to create a globally harmonized regulatory framework for mediation has reached its significance through the work of the United Nations Commission on International Trade Law, recognized as UNCITRAL. We have two international acts, Model Law and United Nations Convention on International Settlement Agreements resulting from mediation. We have also two directives from the European Union and one regulation by EU. In the North Macedonia, the total number of the mediators registered as of June 2013 was only 22, and North Macedonia have adopted the new law on mediation in 2021. What about mediation in the business disputes? There are found to be more amenable to settlement through the mediation procedure in the particular disputes in the field of construction, industry property, copyrights, insurance, damages, and banking, in which the parties are in a long and continuous business cooperation. As such, mediation in business disputes is characterized by various features, which can be summarized as follows: confidentiality, voluntarity, flexibility, and cost and time efficiency. Here are some of the advantages and the disadvantages of the business mediation. The table shows that from 2020 to 2024, which is the period we used to research, we can see how many in a number of the disputes from business, labor, insurance, property, consumer, and family disputes. The next is the chart 1, mediation procedures in business, labor, insurance, property, family, and other kind of disputes. We can see that the business disputes that were completed with agreement and with no agreement. The next chart, we can see the business versus other types of disputes in the period from 2020 to 2024. We can see that with a yellow color, the business in 2020 was in the second place, and the labor disputes leads, and all other years, coming years, from 2021 to 2024, it was all led by business disputes. In conclusion, it is a rule according to which mediation is applied to all those disputes relations in which the parties are free to dispose of their claims, regardless of whether such a procedure is applied before or after the initiation of the court proceedings or other proceedings. Compared to the countries that excel in the implementation of mediation, this way of resolving disputes in the Republic of North Macedonia continues to face difficulty in the gaining the place it deserves. Statistics from the Ministry of Justice of the North Macedonia provide evidence that the applicability of the mediation in business disputes has shown a steady increase so that today business entities increasingly choose to mediate entrusted with resolving their disputes. As a result, it can rightly be concluded that business disputes are more likely to be settled through mediation. Here are some of the references which are used in this research. Thank you.
Thank you very much, Professor Shabani, for your interesting presentation. We have started the panel on mediation and business, and it's a very important and interesting topic for Ukraine as well. So if there are any questions regarding your analysis and research, please use the link to the code where you can read all the questions, and we're continuing our panel, and I would like to give the floor to Natalia Kavalko, who is the doctor in law professor of the Department of Financial Law, Taras Shevchenko National Institute of Law, honored lawyer of Ukraine, head of the Alternative Dispute Resolution Department of Naftogaz Ukraine, attorney and mediator. Natalia will share a very interesting presentation with us, her own analysis and research of mediation for business through in the context of mediation for settlement of the disputes. Natalia, please share your presentation with us. Yes, hello everyone, dear participants of the conference, everyone who is present, dear guests, dear students. Please give me a sign if you can hear me well. Yes, thanks a lot. I am happy to greet all of you, and I hope my presentation will be interesting for you. I would like to give you the greetings on behalf of the Taras Shevchenko National University. We had a very difficult night. Unfortunately, we have some casualties and ruins, but such conferences are very inspiring, and I hope we all together will make a lot of things happen. I would like to continue what Professor Shibani has started, the possibilities of mediation for business in settling of conflicts and disputes. So there, my speech is based on the research that was done on the consent program, and it was implemented by the Ukrainian Academy of Mediation, and I will present you the part of our research, and later on you will be able to check the research in full scope. It's available on all the resources. Why business conflicts need settlement, and what is the role of mediation? Any conflict situation creates a lot of consequences for the company that influence its functioning and results. What kind of consequences those could be? For example, bad relationships and decrease of efficiency if there is a lot of tension in the team. The research shows that over 65% of the problem with performance at the working place happens because of the conflict. It results in the loss of management time, and according to the research of the Myers-Briggs company, the managers dedicate over 4 hours a week to solving the conflicts. It's 10% of all the working time and more than 1 month a year. Also, because of the conflict, some people can get fired or can leave the company. And according to Forbes data, the costs on the search of new employee based on their experience may be up to the yearly salary of their predecessor. Also, there is a risk that the case will go to the court, and the court fee in the first instance for the legal entities is from 3-something thousand hryvnias up to 1 million hryvnias, and for the private entrepreneurs, it can be from 1,000 to 15,000 hryvnias, and those are considerable amounts of money. And it can block business processes or slow them down and result in losses and reputational losses. One of the example is when Elon Musk bought Twitter. At the moment of buying, there was a conflict, and it influenced Musk's Musk's wish to buy the company. However, the court didn't satisfy Elon Musk's application, and he had to pay. And so, in order to mitigate the negative consequences, the companies are trying to integrate some alternative procedures of settlement of conflicts and disputes in the business. And mediation is one of the most popular among them. What are the approaches to integrate mediation to business in the world? First is the internal mediation. So the internal team of mediation is formed and they're responsible for the process. Also, there can be external mediation. So when people are using the services of the external mediation in the terms of the contract, and also it can be combined approach, the combination of internal and external mediation. So let's focus on internal mediation, how it can be implemented. The approach of internal mediation means integration in 3 components. First, the structure, like where in the structure of the company it can happen, into the processes, how it all should be documented, and as a result, the culture of dialogue is being formed and the culture of solving the conflicts is being formed. How the internal mediation structure can be implemented. There are different approaches, and depending on the willingness and internal processes, the company can choose the model they like most. I like the model of creation of specialized department, and mediation is within the competence of there. It can be like ombudsman office, for example, in the World Bank.
There are some companies which would implement internal mediation as a duty of a particular unit within the structure of a company. Another option is the involvement of an external mediators so that they work together with HR professionals. And yet another option is training mediators within the legal department of a particular enterprise. In order to make sure internal mediation is properly operating inside the company, it is necessary to have special operation procedures in place which are embedded in the internal policies of a company so that everybody understands how to seek mediation, where to place requests, what documents should be submitted so that the internal mediation process could take place. So the housekeeping arrangements include having several documents in place, these internal policies, guidelines, and a clear list of documents to be submitted. According to OECR, there should be internal codes in place, so-called corporative codes. And when it comes to mediation, the mediation policy should be written in such codes. For instance, it may state, in case of emergence of any conflict, all conflicts shall be resolved through mediation. Besides, there should be mediation-based mentorship. So if there is no mediation culture within an enterprise, then such a culture should be imposed, because if somebody is not aware of the mere existence of mediation, how he or she would learn about it in the first place? So there should be some outreach actions in place so that people could have an idea of what mediation is. So what are the advantages of internal mediation? In the first place, it is a great possibility to solve a potential conflict within the organization without going external. There is a possibility to react at an early stage. Besides, if the mediation it takes place internally, it is tailored for the purposes and needs of a particular company. However, alongside advantages, there are disadvantages. The first one being the necessity in proper funding, at least at the early stage of deployment, because it is necessary to hire a team to develop documents to persuade people that the mediation is really necessary. Then efforts shall apply in order to promote internal mediation within the company. Besides, there is always room for conflict of interest in order to avoid or at least minimize the situations where conflict of interest arises. There should be several mediators in place rather than just one person dealing with this. A lot depends on the leadership of a company. Respective efforts should be made to make it possible. Now, let us speak of success stories of internal mediation. In this slide, you can see a list of worldwide organizations, institutions having successfully implemented internal mediation. For instance, World Bank is very proud of having 20 mediators as part of their staff. Arcadia Group, which opted for training HR professionals as mediators. The experience proves that in the companies of Arcadia Group where HR professionals were trained as mediators, the rate of conflict dropped considerably, in comparison to other companies under the umbrella of Arcadia Group. Now, Société Générale Group, together with Total Energies, which is a big player in the energy industry sector. So both companies are very proud of addressing the majority of conflicts through internal mediation. The same applies to Ford Motor Company and Shell PLC, which is a major player in the industry and gas, energy and gas industry. This is a Dutch company, and they are also quite successful in the application of internal mediation. Now, let us speak about external mediation. So the key characteristic of this type of mediation is that a mediator involved does not make part of the company, requiring its functions. So the major advantage here is that the rate of impartiality is really high. However, it may be quite challenging to involve mediators whose scope of competency would fall within the needs of a particular company. So in order to involve mediators who are fit for a particular company, one should probably hold an analysis of conflicts which arise in a particular company more often compared to other types of conflict, and thus may serve as a basis for detecting a good mediator or pool of mediators for a particular company. At the same time, the mediators involved should do their homework. They should explore and pick up some information about the companies hiring them, so that the mediator could do his or her job properly. There is, of course, a need for internal procedures anyway, which would guide the process of involvement of a mediator. At the same time, there should be some procedures for procurement of the services of mediator, a tender or something like that should be held. And then there should be a clear procedure for the involvement of mediator and how it should happen. I know that I'm a little bit behind the schedule. Please give me 3 more minutes. I will summarize my intervention. So the advantages of external mediation are quite clear. It is more cost saving at the early stage because there is no need to provide training to potential mediators. Even before conflicts arise, there is a low probability of conflict of interest, and there is the possibility to have mediators with a proper profile for addressing various types of conflicts. And now let us contemplate some international success stories related to external mediation. There are business mediators under the Ministry of Economy, Finances, and Industrial and Agricultural Development of France. In France, mediation is quite omnipresent in governmental sector, especially in relations with private players. So the above-mentioned ministers is one of the leaders on the French market. And finally, we have a mixed model which would possess characteristics of both internal and external mediation. And again, let us skip directly to international success stories. So there was a mediation process between Vargas and Ford Motor Company, where the Center for Effective Dispute Resolution was involved, and the mediation processes were happening in parallel in both internal and external dimensions. And to sum it up, I would like to make the following statement. In the modern times of uncertainty and turbulence, mediation is something which brings in more stability and facilitates finding constructive solutions to have proper settlement at the end of the day. Thank you very much. Thank you very much, Natalia, for such a creative and innovative analysis of mediation for business. A lot of questions were raised today. I am really delighted to have this opportunity to inform you that all the materials, all the presentations will be available on the website of the Ukrainian Academy for Mediation for you to be able to review it later, because we are indeed quite tight in terms of schedule and in terms of time. Thank you very much, Natalia. It is my pleasure to have an esteemed speaker, Svetlana Zapara, present here, and her presentation will be the next one to deliver. Thank you very much, Christina. I'm very much honored to participate in this event, which brought together so many esteemed professionals. So indeed, the Center for Mediation and Reconciliation is the place which facilitates settlement of disputes at various stages, and it is a great honor for me to be able to present our recent developments in the area of labor mediation. So my presentation will be dedicated to mediation in labor relations. I will speak in more details about developments in these areas, about professional standards for mediators practicing in this area, as well as on requirements and accountability. In the first place, I would like to say that in Article 222(1) of the Code of Labor Laws of Ukraine, mediation is mentioned officially. I've recently participated in a conference dedicated to mediation in labor disputes organized by Taras Shevchenko University of Kiev. And I was asked why mediation in labor relations had been in place for 4 years as of that day, but there were not so many examples of its practical application. So in my present presentation, I'll also try to explore this problem and to find reasons for labor mediation be not that present in the real life as we would wish to. I will also speak about labor mediation in the context of Ukraine's European integration. I will speak about the European Commission's assessment of the perspectives of mediation in Ukraine. I can say immediately that the assessment was quite positive. However, they also outlined some room for improvement. In particular, they noted that the introduction of mandatory mediation was a good idea. Actually, I know that it has a quite good perspectives in the future, even though there are currently discussions in respect of the introduction of mandatory mediation. Besides, the European Commission tells us about the necessity of enhancing the application of arbitration of dispute resolution through arbitration. So the Service for Mediation and Reconciliation is building institutional capacity of labor mediation, even despite the fact that there is no clear legislation in place apart from some draft laws which are being discussed by the professional community and partly by the legislator. So what we are advocating is enhancing the application of labor mediation, strengthening of labor unions, involving labor unions in the dialogue dedicated to mediation. All above is done for the purposes of promoting labor mediation among both employers and employees. Besides, I have to mention that in accordance with the existing regulation, the parties are free to choose a mediator for labor mediation. Mediation in labor disputes may be held at the budget expense. We also put focus on the voluntary nature of mediation. It should be noted that in 2024, a professional standard labor mediator was developed. Contributors to the professional standard are listed in this slide. Our service was part of that joint work, and we do our best to promote the above-mentioned professional standard for the purposes of even greater development of professional mediation. In May 2025, we launched a major project dedicated to the training of trainers for labor mediation. So we trained those labor mediation trainers in the city of Turin. The training was delivered by prominent professionals in the area from all over the world. It was dedicated purely to labor mediation and to teaching labor mediation to the attention of those who will be willing to practice or teach in Ukraine.
Now we are working on developing methodological support for training of mediators in the labor field. And now this process is ongoing. Around December, it's planned to start. So whoever is interested in this, on the website of our service and Elsewhere on Facebook, there will be a competition announced. It's going to be free training, but the trainers who have been trained, they would deliver practical training and case studies on solving employment disputes and collective disputes. It's going to take place in 2026. The first pilot project is scaled at the beginning of February 2026. Then we'll have regional trainings. And it's going to be supported by the National Service for Conciliation and Settlement. It's going to be published on the official website of our service. Parties to collective labor disputes and individual labor disputes, maybe judges who would see prospects for labor mediation would be able to also engage professional experts from this list with the involvement of labor mediators. We call on you to demonstrate the support of this initiative by the National Reconciliation and Settlement Service. We again thank you for trust to our work and for all-round support. This is to confirm that the National Academy for Mediation of Ukraine and all the other institutions in the field of mediation have supported our work and have provided professional support, consultations, advice, methodological support, and they were contributing to all our initiatives and we really received a lot of professional support, so I thank you and I assure you that first, as the service together with you, with the professional community, we actively hear to your observations and your needs, and we want to provide for the protection of labor rights as efficiently as possible for the dialects, for the stakeholders, for the employers, for the employees, and for you, dear mediators. Thank you for your attention. I hope I didn't speak longer than expected. Thank you, dear Svetlana. As you see, we see ovations. It's indeed inspiring when I listened to you when you were speaking of the standards for labor mediators. I thought that maybe next year at the conference we are going to discuss the discipline, such a discipline in universities. What do you think about this? All in all, I think that the prospects for labor mediation, we can't even imagine how relevant that is. Again, I would like to say that I joined this conference and I'm very happy to see representatives of the departments for social law, for labor law, and I share this knowledge. We work not only with labor mediation, but with the protection of social rights and social dialogue, but mediation is #1 topic. We consider it to be one of the most prospective ones, and in our opinion, we need to strengthen institutional capacity to have more interaction of the community with the authorities, to demonstrate this support in a comprehensive and systemic manner. And trust me, higher education and education as such is going to reflect that, and we already have, I know, such wonderful examples. Ruslana, close to you, I know how skilled you are and you provide professional level of education in many universities of Ukraine, and we cooperate with many universities and we are grateful for this cooperation. But I hope that the knowledge in the field of labor mediation as such would be disseminated in a broader context, and it's not that it's a potential institution, but there should be an understanding that before I go to court, I have to go to a mediator, no matter what dispute it is. I would like to remind you of timing. So yes, I know that you can speak of labor mediation for a really long while. I asked this question, and then Ruslana says that already we have this discipline on labor mediation that is implemented in Chernivtsi University. So it was very valuable for me to see that dynamic is quite intensive. Dynamics here in the development of mediation, and gives us a chance to see the trends in different fields, but in the context of mediation. I'd like to make one organizational announcement. Those who are in Zoom with us, you can ask questions to the speakers. You don't have to fill out a lot. You can provide feedback, you can ask questions, and also we will show you the QR code with questions that can be added, and those of you who are offline with us can also ask your questions. So, dearest Lana, I would like to thank you for this systemic and comprehensive approach that is extremely important. And given that I'm short time, as a moderator, I can't list all the areas where you work. So our next speaker is now I suggest that we delve into our offline presence, to this wonderful room, and we were going to speak about modern mediation techniques in the enforcement proceedings. So we're going to hear from the PhD in law, private enforcement officer of the enforcement region for the city of Kyiv, chair of the mediation committee and other ADRs of the POs in Ukraine, Katerina Karashuk. Dear Katerina, you have a presentation and you can have a clicker if you need. Dear colleagues, thank you for having me here, and thank you for giving me an opportunity to speak to this distinguished audience. Today we'll be speaking about the experience of mediation and other ADRs of the Association of the Private Enforcement Officers in Ukraine on integrating mediation into the enforcement proceedings. In the world of today, we see the rampant development of mediation as an alternative way of resolving conflicts that helps the parties to reach consensus by an agreement reached after having mediation. Thanks to mediation, legal relations between the parties to the conflict are no longer within the state enforcement, but within self-regulation. The law of Ukraine mediation of 2021 established legal grounds for the use of mediation in different areas of public life and at all stages of the court proceedings, in particular at the stage of enforcing judgments. These norms of the application of the mediation are also contained in the procedural codes and also in the criminal code of Ukraine, in the Code of Ukraine on labor matters, and other legal regulations. The Association of Private Enforcement Officers of Ukraine actively joined the implementation of mediation at the stage of enforcement proceedings. Institutionally, it's done through the establishment of the Committee for Mediation and other ADRs as an advisory body under the Council of the Private Enforcement Officers of Ukraine since 2023. Also, we have approved a regulation, and the committee is composed of 10 private enforcement officers who are mediators, and the purpose is to disseminate information among POs on the alternative dispute resolution methods, in particular mediation. Today, the mediation committee has already been functioning for 2 years. The main areas of work for this committee for integrating mediation into enforcement is lawmaking, involvement in lawmaking, training, and awareness raising activities. An important prerequisite for the use of mediation in our proceedings is the improvement of legislation. In order to develop, draft those changes and make sure that they are implemented by the head of the Council of the Private Enforcement Officers of Ukraine, Oksana Rosetska, we see the establishment of the group that she chairs that involves the Committee for Mediation to improve legislation. The working group has developed a draft law of Ukraine on amending some legislative acts of Ukraine regarding the implementation of mediation in the enforcement proceedings. The main provisions are as follows. The list of the entities involved in the enforcement proceedings mediator is included there, that is selected from the respective register of private enforcement officers who are mediators, and this register is supported by the Association of Private Enforcement Officers of Ukraine. A private enforcement officer cannot be a mediator in the enforcement proceeding where he acts as an enforcement officer, and mediation in the enforcement proceedings can last up to 10 days since the conclusion of the mediation agreement. If the parties reach to an agreement, the fee of the PO or the respective fee is charged in the amount of 50% from the ones set out in the law. Moreover, the parties to the mediation agreement within the enforcement proceedings can be postponed upon the initiative of the enforcement officer or upon the application of the debtor or the creditor up to 10 working days, and there is a respective procedural document set out. Then, after the parties have had mediation, the enforcement officer amends the documents regarding the amount of the fee of the private enforcement officer and the enforcement fee collected by the state. And then mediation can be conducted between the parties based on this mechanism. Also, there is a chance to use the disciplinary proceedings if something isn't right in the procedure. After the mediation, over third of the complaints sent to the committee, a third of them have been withdrawn by the applicants, and therefore the chair of the Council of the Private Enforcement Officers, Oksana Rosetska, initiated amendments as to the mandatory application of mediation when considering the complaints against the private enforcement officer sent to the Association of the Private Enforcement Officers of Ukraine. Members of the committee regularly discussed most feasible use of mediation techniques and shared the use of specific techniques when negotiating with the parties of the enforcement proceedings. There were discussions of the use of mediation when considering the complaints by the participants of the enforcement proceedings, and the enforcement proceeding is the final stage of the civil, commercial, or administrative process. As the judges said, that is the very culmination of justice, and if the debtor does not comply with the decision on his own, the debtor may approach the state or private enforcement officer. As Boris Holko said, who is former head of the civil chamber of the Supreme Court, the enforcement is the most important challenge because the very enforcement of the decisions is the core of the rule of law. And in this aspect, we have state and private enforcement officers who enforce the decisions. And if the judgment enters into force, it doesn't mean that both parties are okay with that. The debtor sometimes tries to preclude the enforcement of the judgment. Therefore, we see that it's necessary to develop a post-judgment mediation because it reduces the caseload on the judiciary and improves the indicators of the enforcement of judgments. Mediation techniques used when the enforcement officers who are mediators used have been proved quite efficient. We know a huge list, and we hear this active listening, assertive communication, etc., etc. We will not cover them in detail now, but choosing these mediation techniques that are available in the enforcement proceedings depend on the specific needs of the individual enforcement proceedings and the parties involved. And mediator can help resolve such problems by the use of mediation techniques, and the mediation brings closer the positions of the debtor and the creditor and makes the prospects of the voluntary enforcement of judgment more likely. Therefore, it's necessary for the debtor and for the creditor to be able to engage in effective mediation, because mediation cannot be successful if one of the parties to the enforcement proceedings has unrealistic expectations or is unwilling to search for consensus. Therefore, mediation is an effective way of addressing enforcement issues. Key advantages are, first, there is no force when the process takes place, the streamlining of costs, maintaining partnership relationships between the parties to the enforcement proceedings, and since one of the precluding factors is lack of qualified mediators who are well aware of mediation and enforcement. Therefore, the Association of Private Enforcement Officers pays a lot of attention to professional development for the private enforcement officers on the matters of mediation. A school STEP has developed and implements the training course that lasts 3 months online. The overall amount of professional development is 94 hours. Professional development has been undertaken by over 90 private enforcement officers together with the training team of the business school STEP and assertive group from Switzerland. Private enforcement officers improve legislation on mediation and the mandate of the private enforcement officer in the context of mediation. On the 30th of October, professor of the Business Academy held a training course in Netherlands on the key skills for mediators. Also, chair and members of the Committee for Mediation further raise awareness of the parties and of the persons involved regarding the mediation enforcement proceedings, and over 20 scientific and practical materials have been published regarding mediation and enforcement.
The members of the Committee on Mediation and other types of alternative settlement take active part in trainings, conferences, roundtables in order to raise up the problems and to discuss the perspectives of implementation of mediation in enforcement. So the Association of Private Enforcement Officers of Ukraine and the Committee on Mediation and Other Ways of Alternative Settlements of Disputes have reached positive results as to integration of the mediation into enforcement. We do not stop at this, and we continue working and the following directions: amendment to the effective law in order to improve the regulation of implementation of mediation, engaging private enforcement officers into training for mediators and the reception of them of the relevant certificates, and creating the register of the private enforcement officer, popularization of mediation through publications in professional publications, and participation in event committee believes that implementation of mediation into the activity of the private enforcement officers is extremely perspective, and it improves the efficacy of the enforcement of the decisions. Thank you very much. Thank you, Ms. Katerina, for this very substantial and interesting report. As far as I understand, the legislation will be further reformed, and the theses that you have mentioned are very inspiring. We can see that mediation is going to develop even in such difficult areas. Thank you very much. And now I would like to give a floor to the other online guest, Maxim. Yes. Our next speaker is Larisa Horodanska, candidate of economics, associate professor, corresponding member of the AEC of Ukraine, associate professor of the Department of Management, System Analysis and International Relations, Mikhailo Dragomanov, Ukrainian State University, Ukraine. So her topic is mediation approach to management of economics resources of an enterprise. Ms. Larisa asked to help her with the slides. Please, Larissa, the floor is yours. Dear participants of the conference, hello everyone. I am very grateful for this possibility to speak at such a powerful international event. I took part in this conference several times, and this year I have the possibility to take the floor, and I'm very grateful for this. The topic of my speech has been already given by Maxim. I think that mediation approach and its usage in business, as we were able to show the connection at this conference, it's very important. And I would like to start my presentation. So the functioning of so the digitalization makes the business processes more difficult. The crisis and threats are increasing the tension in society as well. So the management of the enterprise has to react promptly to the external factors. They have to be flexible, tolerant, stable, and to be able to evaluate the economical resources and plan their restoration. Economical resources are the basis for innovative solutions to the production and operational processes, taking into account the needs of the client. The strategic component of the management of economical resources is the human resource. And the human resource, it's an intellectual potential of the enterprise. Human resource is the catalyst of technical progress, and technical process is the precondition for economical development and country growth. Due to the lack of human resource under the state of war, the human resource managers should pay more attention to preserving the staff. This needs profound mediation process to manage the economical resources. So the aim of our research is to study the approaches to mediation in managing the economical resources. The aim of the research is in providing strategy of constructive interaction between different different stakeholders, managers, teams, and also about the technologies of usage of economical resources and partners within the negotiation process, taking into account the common interests of the parties. and also signing the memorandum about cooperation. Mediation is beyond the conflict solving process under the modern condition. It's more an art of a compromise. It changes the type of communication from authoritarian to facilitative. Thus, the approach to management of the team change. It gives the place to dialogue and constructive cooperation. The management is able to organize interaction in the team effectively and to take the most optimal management decision. Also, we have to take into account that the life is very dynamic, and thus the manager, the leader, has to be able to use the modern informational technologies effectively, including AI. And we have come forward with the definition of the uh, mm, key features of usage, the mediation. First, the conceptual basis in managing the economical resources of the enterprise. So mediation approach should be based on the principles of partnership, dialogue, and search for mutually beneficial decisions while using all the tools available for solving the conflicts. In managing economical resources, which means coordination of relations between the business owners, managers, members of the team, and workers regarding the production of goods, providing the services, etc. Implementation of mediation is very relevant during the strategic negotiation, taking into account the interests of different stakeholders of the business process. According to the researchers of Mondata, Medina, Euvema, mediation management is not only the technology that is aimed to settle the disputes, but it also is a strategy of decision making, creativity, emotional intelligence, and responsibility, ethical responsibility of all the participants are taken into account. When we're talking about the economical management of economical resources, we have to stick to the principles such as targets, economical targets of the enterprise, ensuring the balance between efficacy and social justice, the usage of communicative and analytical technologies to maintain effective managerial decisions. As to the intellectual potential and emotional intelligence of people at the enterprise can also benefit from mediation approach. Emotional intelligence of the manager and their ability to manage constructively and manage own and emotions of the team is very crucial. And I can show you later the link, but it's my paper published in the collection of scientific work of this in Kiev and Kharkiv, Vivat Publishing House. I will send you the link later. Based on this paper, the level of trust inside the team is very important, and high level of emotional intelligence of the manager helps to transform the conflicts inside the team into the possibilities to constructive mutual work. So effective management of the team with the help of mediation can help minimize the risks of conflict and optimize the adaptation of the enterprise under the risky conditions. The managers who have high level of emotional intelligence are natural mediators who are not only able to analyze the data, but also to harmonize the relationships in the team and form a positive psychological climate. It results and in a decrease of expenses and improvement of efficiency. Also, leaders' ability to use informational technologies effectively in order to do the analysis of available economic resources and to apply AI helps to predict more accurately, to optimize different processes, to create the models, etc. The synergy of the intellectual potential of the leader in AI within the context of mediation approach is the key factor of effective management and team interaction. The usage of AI helps to distribute economical resources effectively due to the algorithms of optimization, to decrease the human errors, to increase the speed of managerial decisions. However, a human is still needed to exercise the ethical control to avoid bias or some decisions that are in the contrary of the corporate values or values of humanism in the society. Under the crisis conditions, the manager becomes a mediator between business and society. And also the ethical questions of responsibility of business has been taken into account. Also, my paper talks about the technology of synergy of a person and AI in managing the economical resources of the enterprise, as it creates the new quality of management, which helps to increase the efficiency of the business, its flexibility and resilience in the modern context. So the technology of synergy between human and AI was proposed based on the innovative approaches, and it contains three stages. First stage, automated collection and processing the data about the economical resources of the enterprise. Current stage, analysis and the interpretation of the data, taking into account also intangible factors such as moral and corporative values, motivation system, internal and external risks. And third stage, mediation. It takes into account Larissa, the time is almost up. Yes, just 2 more minutes. So integrated taking of the decision by the teams of managers with the usage of algorithmic objectivity of AI. The implementation of this technology will increase the potential of the enterprise due to the mediation approach. Mediation practices in approach to the economical resources helps to decrease the number of conflicts during decision making, to provide for transparency and trust, and increase the efficiency of the communication inside the team, to make sure business have social responsibility. As the mediation approach at the enterprise is being formed in partnership between managers and teams, it should be looked into as a strategic tools in managing economical resources for the sustainable development of the enterprise. Thank you very much for this possibility. Thank you very much, Larissa. A very substantial presentation which shows how mediation approach can combine emotional intelligence, communication, AI, and management of the enterprise resources, and it gives us the understanding of balance of efficiency between of the balance between efficiency and social responsibility. Thank you so much. I would like to give the floor to Ms. Alexandra Filip, candidate for law, associate professor, director of the legal clinic of Lutsk National Technical University, associate professor of the Department of Law of Lutsk National Technical University. Her topic is classification of legal conflicts in contractual regulation as a prerequisite for the effective application of mediation. And we do ask you to make your speech no longer than 7 minutes. Thank you very much for your understanding. Thank you very much. I'm very happy to see your eyes on me, not in your phones. So as to the classification of legal conflicts, I will try to speak as structured and as laconic as possible. So let's jump straight to the classification. While practically observing how the contracts business are being implemented, I made some outcomes. So first group of conflicts are the conflicts that may occur while fulfilling the obligation. Someone is failing to fulfill the obligation in full scope or partially, or fulfilling the obligations improperly. So there are a lot of conflicts about the quality of products, especially when there were no standards discussed before. The second group is the conflicts regarding the interpretation of the contract clauses. Like, for example, there is such a wording that says like implementation, exercising of application when possible. So really it gives a lot of space to the conflicts. And the third group is the more acute and more painful group because parties have some economical losses. It's the group of liabilities, because when we talk about the liabilities, it means that there were a number of conflicts and violations which have different backgrounds and nature. So when we understand what kind of the conflict it is, we are more effective in solving this conflict and helping the parties to solve this conflicts and choosing the tools. We understand what skills mediators should have to be able to mediate this conflict. And while observing the conflicts, we can look at it not only as something negative, but at the possibility to improve, for example, the wordings in the contracts. And we can, at the stage of signing the contracts, when the parties are still kind of in love and they are still pursuing the common interest, we can advise them how to do it better, to agree on all the crucial moments. So this is all from my side, and I'll be happy to answer your questions. Thank you very much for your attention. Thank you very much, Ms. Alexander, for your understanding, and I truly hope that we will have the possibility to read the full text of your presentation in your keynotes, your extended keynotes. So we are going forward, and now I would like to invite the candidate of law, professor and Deputy Head of Department of Law from Odessa Mechnikov Law University, Tatiana Stepanova. Her topic is the change of approach to the application of consolidation processes in domestic judicial procedure. Do you need help with the presentation? Can you try to unmute yourself? Yes, great. Yes, because I had some difficulties in turning the sound on, and I will put my timer on to make sure I am not taking it, it doesn't take it too long. So Miss Larissa brought up a very interesting topic about management.
And her statement somehow intervenes with the topic of my presentation, because manager learn some of the advertisement, some of the marketing, some of the management. And they say that if you talk about direct marketing and you then you may approach somebody in the street and say, I'm a good cooker, and this is direct marketing. If somebody approaches another person and says she is a good cooker, then it's indirect marketing. If you approach somebody and say, let's go to our bakery, we have great donuts, and somebody tells you in response, oh no, thank you, I'm not really into donuts, it means that you have wrongly detected your target audience. So this is like a before. Something I would like to say as a preliminary introduction to my presentation. I was trying to follow all the presentations which were delivered previously. Unfortunately, it was quite challenging for me because we still have these electricity cuts, constant electricity cuts in our city. So I would connect and disconnect and reconnect again. I truly hope that I will have this opportunity to get familiar with the presentations and reports in the aftermath of the conference. Now, back to the topic of my presentation. There is a trend for wider application of reconciliation procedures in various types of jurisdictions when it comes to court disputes that became possible since 2017, then at a later stage in 2021, the amendment was introduced providing to suspend a court trial for the time of mediation. Hopefully, in the future, as rightly mentioned by Dr. Valanchus, we will have this mandatory obligation of, and mandatory culture, legal culture of going for mediation before taking action in court. Now, speaking of judges, when legal professionals become judges, their scope of functions become completely different from all that they would be doing before. So from the moment they take office, they need to make decisions, issue decisions which may make unhappy both parties, or at least one of the parties. So my proposal in this connection would be to cast aside dispute court facilitated or judge facilitated dispute settlement because it is not that popular. I hope you can hear me well. Yes, we can hear you, but your image was suspended though. And now I think we are facing some of technical issues here. We may want to give a moment to the speaker to get reconnected. Please let me know, dear Tatiana, if you have the possibility to reconnect. We need to voice out some of housekeeping arrangements right now. It's 1:05 p.m. right now. There are some sacred things which no one would ever want to encroach at. So lunch is something very, very important. So we won't take lunch away from you. Tatiana is back. Could you please squeeze your speech into 2 minutes max? So I'll try to finalize what I was saying, especially considering that I'm staying between people and their lunch. So coming back to my point, it is better to get away from judge-facilitated mediation towards a broader context, because when a judge just lists what can be done by parties as an alternative to court proceedings, that is something which is very little understandable for them. So for the parties, for ordinary people, it is just a list of words and expressions with no meaning behind it. That is why I think it is worth enhancing explanations provided by court to parties in terms of mediation, and second, enhance the means of alternative dispute resolution or alternative reconciliation. This is something which would allow to relieve courts from their burden and would be beneficial for the parties as well. Thank you very much for your attention. Thank you. Thank you for the opportunity to speak, even though not without interruptions. Dear Tatiana, you've raised very important issues today, even in this context of the lack of time, and I think that you gave some fruit for discussion to all the participants. And our next speaker is Ms. Lydia Nesterenko, Assistant of the Department of Public Law, Coordinator of the Mediation Service of URI Fedkovich University of Chernivtsi, and mediator of the NGO Bukovina Mediation Center. Dear participants, thank you very much for having me here. We will intervene on the topic mediation and transitional justice points of contact. I understand that at this point it is close to impossible to talk about any reconciliation with our enemy, because the enemy is destroying our homes and attacks our people. However, if we think at longer perspective, we will see that all people seek to be free of all types of violence and feeling themselves in security, so safe and secure. So in order to achieve this ultimate goal, the concept of transitional justice was introduced. So what is transitional justice? It's a set of processes and mechanisms related to the attempts of the society to overcome complicated consequences of major violations of legality in the past, to reconcile with the heritage, notorious heritage, in order to provide accountability, justice, and achieve a reconciliation. This is done through, among others, through reparations and through reconciliation. This is something which need to be developed already, rather sooner than later, and rather at this stage before the war is over than in the aftermath of the war. So what are the four pillars of the transitional justice? They are facilitating justice, establishing the truth, reparation, and institutional reforms. As we all know, mediation, which can be part of transitional justice, has a clear structure and is based on certain rules. Only if the mediation process is neutral, objective, impartial, equal, and respectful, we may talk about achieving the ultimate goal of the mediation as such. Now, when we speak about transitional justice, when it comes to restoration of justice, the goal is not only to hold the perpetrators liable, but also to return this feeling of restored justice to victims and witnesses of crime. And here, mediation is something which may be of help because mediation may facilitate dialogue and promote reconciliation in the cases where it is possible, and will not do that in the cases where it is absolutely impossible, such as, for example, cases of rape crimes against civilian population committed in wartime and some other cases. Now, now let us speak of the second pillar of the transitional justice, which is restoration of truth. A commission for truth and reconciliation may be established as an important element of the transitional justice system. The commission is expected to facilitate the establishment or re-establishment of truthful and rightful course of actions. The existence of such commissions is very helpful in situations where there is a need to reconcile parties which may have completely different views of what happened in the past. The third pillar is the payment of reparations. So the reparations are the form of compensation for inflicted damage. Reparation can be paid as some cash or be given as a place of residence or provided in any other form. Reparations are expected to compensate damage and renovate. And finally, when it comes to the fourth pillar, which is support of institutional reforms. In the aftermath of the war, we will need to restore confidence and trust in public institutions, which were expected to a certain extent protect us, but failed to do so, and thus lost the trust of the population. Thus, we may conclude that unfortunately wars will continue happening across the world. That is why the transitional justice will always be something important and topical. It will be different for each country or for each situation. In the meantime, whatever the context is, the transitional justice is there to facilitate restoration of this feeling of justice, human dignity, for payment of compensation and for other purposes which are extremely important for countries in the aftermath of the conflict. Thank you very much. I think I did it and I managed to fit within my time slot. Yes, thank you very much for making such a great attempt. The topic is very complex and vast. 5 or 7 minutes is not enough any way to